Okay, well, good morning and thanks for being here and welcome to our panel, Aerospace Technology, Policy and Protection of Intellectual Property, the Role of Patents and Trade Secrets in the New Space Race. We're going to start with Graham Farrow. Am I pronouncing it right? Farrow? Okay. Graham Farrow is
and it's okay. I've got an intro here ready to go if that's all right with you.
Yeah, go ahead.
Wonderful. So thank you, Anna. I appreciate that. So my name is Graham Farrow. I'm a director at Stern Kessler, Goldstein & Fox, specializing in intellectual property law, which is primarily patents and trade secrets. My practice covers the full spectrum of intellectual property from application drafting all the way through enforcement and defense. I've also litigated at the Patent Trial and Appeal Board, the U.S. International Trade Commission, and in district court. With me today are three distinguished panelists. I've got Troy Prince here with me in person, Bridget Smith, and Dr. Alistair Scott joining remotely. So thank you all for being here today. And with that, I'll just give a brief introduction of our panelists. So I've got Troy Prince here. He's the Vice President and Chief Intellectual Property Counsel of Raytheon Technologies Corporation. Troy leads an international team of attorneys and paraprofessionals that span all of Raytheon Technologies business units, and they're responsible for all aspects of intellectual property acquisition, protection, and use across their global enterprise. Troy was previously the chief at Pratt & Whitney, which is a Raytheon Technologies Corporation business unit. And prior to joining Raytheon, Troy was a partner at the IP group of Thompson Hine. There, he counseled clients on a broad range of IP matters, including litigation, licensing transactions, and patent prosecution. Prior to becoming an attorney, Troy was a research engineer and is an inventor on over 50 issued patents. Looking to Bridget Smith, who's joining us remotely. Bridget is the Assistant General Counsel and Head of Intellectual Property at Relativity Space, an American new space company that is innovating 3D metal printing to manufacture rocket structures and engines. Bridget earned her JD cum laude from Arizona State University and her MS degree and BSc degree magna cum laude in chemical engineering from Case Western Reserve. Before joining Relativity, Bridget was in private practice and represented clients in over 160 PTAB trials. She led a precedential win at the Ninth Circuit in a trademark appeal and has had her amicus brief for an inventors group cited in the Supreme Court case United States v. Arthrex. She has twice been named one of the top 50 women in PTAB trials by the PTAB Bar Association, and she currently serves as vice chair of the American Intellectual Property Law Association's PTAB Trial Committee, and she is co-chair of the Orange County chapter of CHIPS, an international nonprofit legal diversity organization directed to advancing women in intellectual property. And finally, we have Dr. Alistair Scott, also joining us remotely. Alistair is a New Zealand, Australian, and European qualified patent attorney, and he is the Vice President and Head of Intellectual Property at Airbus. Alistair's technical background is experimental nuclear physics and has divided his career in IP between private and in-house legal practice, initially working in New Zealand and the UK, and subsequently in industrial IP practice. He was working for Hewlett-Packard, specializing in European and emerging market intellectual property matters. Alistair joined Airbus in 2005 as head of IP for Airbus UK and took up the role of global head of intellectual property for Airbus and Airbus Group in 2010. Alistair's current responsibility covers the Airbus Group, including primarily Airbus commercial aircraft, and he is not only responsible for the management of the overall Airbus IP function, but he additionally maintains operational activity in IP litigation, strategy, and partnership development. Alistair is also a fellow of the Royal Aeronautical Society and sits on the council of the IP Federation in the UK. So among all the expertise we have here, we've got a rocket scientist and we've got a nuclear physicist. So I think we're in great shape. So with that, we've already talked about the name of our presentation here, but we hope to provide insight on three topics for you today. Specifically, the relationship between IP investment spend and overall company valuation, how aerospace companies should approach risk mitigation and protection of IP during a time of increased employee mobility, and finally, the jurisdictional impacts and considerations on IP protection in the aerospace industry. And before we start, I just wanted to give the disclaimer that anything said here today is only for the purpose of this discussion and does not necessarily reflect the views of our panelists or their respective companies. All right. So with that, I will turn first to Dr. Alistair Scott. Alistair, if you can hear us and we get through all the technical difficulties, in your view, what is the relationship between IP investment spend and overall company valuation? Specifically, how should aerospace companies approach their IP spend?
Okay, thanks, Graham. It's a good topic. I'm going to split it into two parts, if that's okay, talking mainly about the aerospace industry generally, and then focus on some startup considerations, including space startups. First thing, I guess, and also, Graham, can you keep an eye on the time for me and tell me if I'm going too slowly? Yeah, firstly, what do we mean by IP spend? Speaking as an Airbus person, our IP spend is primarily on the patent portfolio development. We have budget lines as well for things like IP advisory support and general legal costs and disputes and so on like that. But the main thing really want to talk about here is IP investment, which is what we spend on protection of our technology. So to me, when I look at these two topics, to me, it's completely context driven. For Airbus as a large, well-established international global aerospace actor, we follow a fairly classical profile, if you like, on our IP spend. We have a dual axis target in terms of IP or patent protection strategy, focused mainly on competitors on one axis and suppliers and partners, technology development partners, sorry, on the other axis. So when we're looking at how this affects how we value the IP in the company, what do we spend the money on, and where do we focus our efforts, it's fairly classical. We're looking at where our main competitor is, which is naturally Boeing, as well as some of the other smaller players such as Embraer, Superjet, Sukhoi, and some of the new emerging Chinese aircraft companies. Jurisdictionally, we look at a fairly standard, if you like, mix of nations, classically US, China, Europe. China's very important to us. So the relationship between that is, and our valuation is, we're directly trying to protect our products, and at a component level, the technology we develop with technology partners. So we have these two sort of axes. It's not a complicated IP strategy for Airbus, but it suits us. But talking about startups, it's quite a different proposition, I think. In our experience, the relationship between IP spend and valuation is quite different. The drivers are different. Generally, they're very early stage, low TRL, technology readiness level stages. So their motives are more to attract investment or engagement, perhaps with other partners. So in that case, from my own experience, generally their patent filing and budget, what they're happy to spend on, is much more driven by time and speed. What they want is to extend the process as much as possible to minimize the amount of cost at the outset. In our interaction with startups, we generally find that when we assess their value, we look at we do due diligence on their IP asset portfolio. So from their point of view, the correlation between what they're spending on IP assets needs to be balanced with our perception of them as taking a prudent approach to the protection of the technology which we're interested in. If we look at a startup which isn't spending anything on protection, or it has really no patent portfolio, it raises questions about really what are we getting into in terms of where's the investment going and how that can be monetized later. So they're two very, very different propositions from my point of view when I contrast them. For a startup, balancing the short-term financial burden of protecting their new technology, or to the extent necessary that a funding entity or a potential technology partner can understand that they have control of the technology assets that they have. And for us, that's the main correlation between the effort and the budget that would be put forward, or investment in IP versus the valuation of the entity. I'm not sure if that starts to answer that question, but that's fairly much our position. Space startups, we don't really differentiate so much in my own experience. They have the same time constraints. Generally, they're smaller entities, more agile than us. I mean, Airbus is a very large organization, so we don't move very quickly. Again, for them, it's buying time in terms of their IP investment. Whereas for us, it's a fairly conventional time process in terms of how we get our patents and how we develop our patent portfolio. So that's my initial feedback on that. I don't know if the others would like to jump in on that with other comments.
Sure, I'll go ahead. This is Troy. I'll go ahead and kind of add on. So, kind of echoing what Alistair's talking about with respect to startups in particular, one of the things that we like to look for and understand is how those startup companies are actually protecting their overall IP portfolio, right? The thing with patents is that you can easily spend a lot of money on patents and not get very good protection, right? And we spend more time kind of understanding how the startup is actually targeting their patent spend, how they're managing it effectively, how they're balancing it with other things like trade secrets and other kinds of secret ingredients to understand how they're actually attempting to protect what differentiates themselves in the market from a total valuation perspective. So it's much more than just simply looking at the total number of patents they have or issued patents, but rather actually trying to understand their actual strategy that they're following. We've made investments in companies which have very few patents, and also investments in small startups that have a lot of patents. And it varies in excuse me, it varies in part based around what they're targeting and what kind of product they're attempting or service they're attempting to bring to market. So it's very much a case by case basis, but it starts with that strategy.
Yeah. Just to supplement that a little bit, one of the things we do in due diligence is to look very closely at the strategy they're following, filing provisionals, filing multiple inventions in one application using the PCT process to delay. And that can actually be an insight into how sophisticated their IP strategy is for their particular technology. But yeah, as you say, it's a window into how they see their own technology and protection. Yeah. Sorry, Bridget, I see you're muted.
No worries. So I'll just jump in here with a couple of comments specifically to New Space, which has a lot of things that set it apart from other startups in aerospace. So New Space is kind of in a unique position historically. And when I'm talking about New Space, I'm talking about, the launch service providers. So things like SpaceX, Rocket Lab, Virgin Orbital, and Relativity Space for that matter. And historically, launch services providers have not relied on patents to compete with each other. And patent lawsuits involving pure rocket technology are pretty rare. So, and when I'm talking about like this, I'm talking about the technologies that get you from the ground to outer space, not like aircraft or things of that nature. Instead, so the launch services providers have played the appropriations game, trying to get money from NASA to get a competitive advantage over their other people in this space. And so if you survey patents in this narrow area, when I'm again talking about the launch services, I was stunned how few patents there are, considering how humanity has been going to space for 60 years, right? And if you look at databases and middleware, for example, like there's hundreds of thousands of patents, and there just isn't that, right, in rocket technology. And the launch service model changed, I'll say about 20 years ago when SpaceX started providing private launch services separate and apart from the NASA appropriations. But still, SpaceX and others in this space have not been using patents to get a competitive advantage over one another. SpaceX has very few patents in pure space. It has many more in technology areas where there have been historically a lot of filings. So telecommunications and satellites around its Starlink network. But so we have that historical, I don't know, antipathy is probably the wrong word, but just reluctance to patent. Overlaying all of this is that propulsion technologies have export controls around them, the international traffic in arms regulations. And for some propulsion devices, if you are innovating in this area, you can't patent them even if you wanted to, because you'd be held under a secrecy order. And when you have limited budget, wasting money on something that's going to be held under a secrecy order doesn't have a lot of appeal. And finally, getting to space just isn't cheap. It takes an enormous amount of infrastructure. If you're a startup with limited resources trying to put a rocket into space, you're going to spend it on infrastructure or on, or you could, choose to spend it on patents that may or may not be subject to the secrecy order in a technology area that historically has not seen a lot of patenting. It's a hard sell to startups in this space to get, to spend their money on patents, particularly because most companies in this space are not looking right now to be acquisition targets. They're looking to be standalone launch services providers like SpaceX. They're following the SpaceX model. And for that matter, there haven't been a lot of splashy acquisitions of somebody that's made it to outer space, as far as I know. Now, the paradigm will change as new space matures, but it's pretty young. 20 years is pretty young for a technology. And for now, I know a lot of startups are choosing the path of trade secrets. I already do see that changing somewhat, but it's not changing rapidly.
It's interesting what you said, Bridget, about the antipathy towards filing, because I think I even detect that to a sense in our own space business. Often it's a more academic approach and not commercial. So yeah, there is an inbuilt almost antipathy towards IP protection as such, as opposed to our commercial aircraft business, which is highly competitive, highly IP driven and leveraged. So it's a very different world. You're right.
Right, and I should mention that when I get outside the narrow area of just pure launch services and you get into the other areas of aerospace, I would consider the dynamic to be very different. This was just a comment on the very, very niche area of new space or launch services, new launch services that are providing commercial like satellite launching to their customers. It's a pretty unique area that has that sets it apart from a lot of other technologies.
Yeah, I think the bulk of our IP portfolio in the space business is mainly around satellite technology, not surprisingly.
Yeah, I'm very similar on our side as well, right? So, somebody else basically builds the bus to take the stuff into orbit, and then that's where our stuff comes in, right? So, yeah, it's interesting to to talk about kind of like that shifting viewpoint about IP and more of an academic viewpoint of it. It's a little bit like the open source software mindset sometimes shows up in the same way. And it is interesting to see the balance and understand what different IP portfolios are attempting to achieve for their companies. Because even with SpaceX, right? You look at that portfolio, and I objectively look at that and I say, there is a strategy here which is designed to maximize and protect the company, right? Is it necessarily protection in the traditional form of a patent enforcement action against somebody else? No, but it's protection of a different sort, which is to basically be a hard target for somebody else to go after. So it's an interesting strategy, which is sometimes missed in some of the hype around it.
I guess for us as well, some of the technologies in the launcher business, which it's a joint venture now for us, our patent policy is more focused, I think, or has a balance of focus on materials science, applications for IP elsewhere in our business in defense and space and commercial aircraft. So we're not just looking narrowly at the launcher business, we're looking at technologies perhaps in that portfolio that could be used elsewhere. So that's one thing which may drive some of our patenting decisions.
Yeah, absolutely. I mean, the interesting part is, right, the type of advanced material science that makes, some of the new launch capability available today, right, particularly like reusability and things like that, are very relevant across like the entire portfolio of aerospace products. And I think that's those kind of key cross connecting technologies that particularly rely around material science are very interesting. And sometimes the protection around them. Oh, go ahead, Alistair.
I was just going to say it's fairly open public knowledge that our work on hydrogen technologies for civil aircraft and things like composite tank designs and hydrogen handling and management. There's a clear crossover there that we have never encountered before in normal fossil fuel aircraft.
Yes, indeed. Yeah, handling hydrogen is interesting, right? It's something which the launch industry has done for the last 40 years, and is now basically breaking out of dedicated launch industry and moving elsewhere.
Yeah.
Thank you all. That was a great insight there. And I think one common theme is that there has to be a strategy. And what that strategy is depends not just on one aspect of IP, but on many different aspects IP, including patents, but especially trade secrets. And so that's a good segue, I think, to our next topic. So Bridget, I'll ask you to go first here. How should aerospace companies approach mitigation of risk and protection of their IP due to employee mobility? And by that, I mean employees changing jobs due to opportunity, or also to downsizing. So in the aerospace industry, as well as many industries, there's been layoffs as well as just unprecedented demand for people with skills. So how does the aerospace industry, and in particular startup companies, how should they approach this, and what should they be looking to do?
Yeah, it's a great question and a difficult one, because it's honestly a topic that would take hours to answer fully. And so I'll have to do the ultra compressed version of it. And I think the answer depends a lot on what part of aerospace your company is in and the stage of your company's life cycle. So what might be a good practice for an aircraft manufacturer is very different from, say, a launch services provider, or what's good practice for an international conglomerate is totally different from what a startup that operates only in the United States. But I think there are some factors that are generic to all companies, regardless of industry, and not only aerospace, but databases or software, what have you. And I'll speak to those too. So with employee mobility, what I like to do is break it down into the different phases of employment, the different risk vectors that exist at every phase of employment. And it's impossible to stamp out all risk. Like, you just have to accept that. And it's impossible to work 24 hours a day, every day. So complicating all of that is that there's no set of laws. There's no rule book, no code of regulations that says you must do this to protect your trade secrets. You can never do this to protect your trade secrets. So you have to think creatively about your unique company and whether there are reasonable practices that can reduce those risk vectors, and what in the future will be seen as reasonable measure in the unfortunate event that a loss occurs and legal action needs to be taken. So you try and think, what's going to provide me with the best bang for my buck under the unique circumstances of my aerospace company. And before I start and talk about some of those practices, I want to recall, I was thinking about this morning. There's this 20-year-old movie starring George Clooney and Catherine Zeta-Jones that's called Intolerable Cruelty. And in it, George Clooney is a divorce lawyer, and he's named Miles Massey. I don't know why I remembered this. And this big theme of the movie is that he wrote a bulletproof prenuptial agreement that's called the Massey prenup. It's ironclad, it's never been defeated. And if you have the Massey prenup, story is over. And it plays this role like people will sign the Massey prenup as I've now bound myself for all eternity, and it can never be challenged. So I was talking to a lawyer recently who was implying to me that if you protect your trade secrets with robust NDAs, you're good. And I thought of, oh, wow, so there's a Massey prenup for NDAs. That's great. But it's not a good way of looking at the entire picture. An NDA is only one tiny piece of a larger puzzle of all these things working together. And so with that story in mind, let's think about the life cycle. An employee is recruited, they're hired, they work at the company, and then they exit. And your question specifically pertains to changing jobs or being downsized. But like those all play together, right? Because if they're downsized, they're probably, they're downsized or let go, or they change jobs, right? They're immediately starting somewhere else. And so we'll set aside, the employees for now that work for their employer for 40 years and retire with a gold watch. And we'll look at those highly mobile employees and what they're going through. And we'll think first about recruiting. And mobile employees create an enormous inbound risk for a company, for an employer, because they may have the trade secrets of others. And your company doesn't want those trade secrets. And startups, a lot of these little startups in aerospace are people coming, from who knows where, may not have a great understanding of their responsibilities to trade secrets. I find it difficult sometimes to rely on inbound employees having gotten that good trade secret training and baseline that they need. So depending on the nature of a hire, you may need to train your interviewers to know when to cut off an interview if a candidate starts talking about trade secrets or bragging, right, that he or she has this valuable information that would make them a strong hire. In fact, the opposite is true and makes them a risky hire. So handling those types of people with special care is important. It could also be reviewing prior employment agreements to determine if your new employee has, for example, a non-compete or non-solicit clause or some other clause that would create some undue risk, assuming it's enforceable. And maybe it's as simple as asking yes or no. Do you know the trade secrets from your former employer? I don't want to know them, just yes or no, do you have them? And yes or no, given your understanding of the job description, do you think you can perform your responsibilities without using or disclosing your former employer's trade secrets? I mean, there's lots of really creative approaches that you can take in these difficult situations, and they kind of have to be addressed one at a time with savvy practices. And you need to just get really creative about it and automate them to the extent that they can be. So next we'll talk about hiring, and hiring creates a new set of risks. Not only do you have your inbound risk now, but nascent outbound risk, because as soon as they're onboarded, they're going to start ingesting the trade secrets of your company. And here's where you think about your Massey NDA and other agreements. And training, especially, I can't emphasize how invaluable training is, because it sets the tone for how your employer and employees are going to treat intellectual property. It creates that, if you have questions, you can come to me. I am a person, I am a resource that is here to answer your questions. And that's a very important in an environment where, like I said, you can't necessarily trust others in this space to have provided this one-on-one training. So we talked about recruiting, we talked about onboarding. We'll also think now about ongoing employment. That could involve periodic training so that, employees know when to flag issues. But really crucially, what is most urgent at this ongoing employment phase is that the employees have a good understanding of what the company considers a trade secret and what to do when there are tough questions. And there are plenty of ways to do that other than to have a ledger, which I know I hear that so often in presentations. You need to have a ledger of your trade secrets, but it's just impractical for a lot of companies. And there's lots of approaches you can take, around identifying categories of information that the company considers to be trade secret. You just want them to know this is a trade secret and you're not allowed to talk about this. And if you see a problem with us, here are the people that you need to know, or that can do something about it. So yeah, and then finally we'll close with the most stressful part of the cycle, which is exits. And people don't leave jobs voluntarily because they're happy and content. Instead, they're unable to balance work or obligations outside their home. They're underpaid. They're unsatisfied by their work. And then particularly when there's an involuntary severance, can be a lot of ill will about the departure. So exit, of course, is when your trade secrets are at their highest risk. And hopefully your education will have paid off at this point, and the employee will clearly understand what they're obligated to keep trade secret and what they can use as part of their ordinary skill set. That can be reinforced in an exit interview if time or resources allow. But one thing that I think is a great practice is for the HR department to have a conversation with the person's manager, because what is really boiling down to at exit is an assessment of risk. And that's, exposure to trade secrets during employment. How much do they know? And are there behavioral concerns that are leading you to believe that this person can't be trusted, right? And it could be anything. There could be a host of behaviors. And they don't necessarily have to do with behavior around intellectual property. It could just be recklessness in other aspects of their job. You just want to have a heart-to-heart. Somebody needs to have a heart-to-heart with the manager, identify that level of exposure and risk, and then take appropriate actions at exit or even after exit in order to make sure that they're behaving as they should. And that could involve different levels of touch depending on the role of the employee in the organization and their new role at their new employer. So that's kind of my super high spin through trade secrets for in aerospace.
Thank you, Bridget.
So I'll go ahead and start on from the room here. So this is Troy. I like everything that Bridget outlined. It's really good, really comprehensive. One other aspect that's a little bit more soft and squishy that I think sometimes as lawyers we forget about, and that's the importance of building culture and also helping people understand kind of the mission, right? What are we doing as a company? Why are we doing it? Why are we doing this here? And what is important about the secrets that we work with that mean that they need to be protected, right? That kind of understanding dovetails with the more mechanical understanding of like, this is a trade secret and this is what you need to do with it, but also understanding why are these things important and why do they need to be protected? That kind of reinforcement is something that can happen through everyday interactions, right? With the engineers who are working on a technology, as you're going through, even doing things like working on a patent application, working through, intellectual property questions, resolving, relative to suppliers and things like that. Those are all places where you can build that culture of understanding. And then also to help reinforce and to empower individual engineers to understand that it's their responsibility. They have the keys and they have the tools to protect the intellectual property that we have that basically makes the company special. I think those are things which are, indeed very soft and squishy, but, they're important. And, because particularly on the intellectual property legal side, we have a tendency to cut across multiple parts of the company. We can help build that culture and really take a lead in helping to develop that understanding, which I think is really valuable in the long run. And it helps people understand, even in a situation where you have a departure. Beyond that, right, there's also other kind of technical solutions and things like that, which just can't be forgotten, right? It's interesting, right? The hygiene around a departed employee and like turning off access to like things like web resources or cloud-based resources. It's amazing to me how often, like when we look at startup companies in particular, right, you'll go and you'll see like, oh, well, they have like 50 employees listed on their cloud server. But when you look at their roster, they actually only have like 42 employees, right? What happened? Where's 8 people who left? Oh, they still have their access credentials. What are they doing? It's one of those things where it's easy to kind of lose that. And that's why, like, as Bridget talked about, that relationship with human resources and whoever the employee's manager is, trying to create that process, right? This is what happens. When you have somebody who basically says, hey, boss, I'm leaving. What does that trigger, right? What are the questions that manager needs to think about? What is this employee working on? Where is the employee going? Oh, they're going to our direct competitor. Oh, maybe I should be thinking about turning off network access right away. What kind of resources does the employee have, right? Do they have things like exceptions so they could use USB keys? Do they have external storage devices, right? All these sorts of questions, should come naturally, and you need to kind of build it into the system so that you have partners with both the engineering managers as well as your HR folks. So that way they're your eyes and ears, and they also make sure that these things happen, right? They're like, oh, well, wait a minute, why do I have 12 employees have network hardware, but I only have 11 employees on my payroll? Ask the question, figure out what's going on, and terminate that access. So those sorts of things are good, like hygiene and discipline. They're definitely really important, and it's important to kind of build into the culture.
Yeah, it's really interesting. I have to say, the first thing to say is that sitting here in Europe, in particular in France, workforce churn is very, very low. Compared to the US, we simply don't have people leaving and new arrivals at the same rate. People, especially even at Airbus, people tend to stay for a very long time. So, I mean, our solution to this problem is we have the usual mechanical network and the physical means to, as Troy's just said, I think a lot of companies have this type of infrastructure deployed. But for us, to be honest, it's culture that trumps everything else. And that's really awareness. I think, Bridget, as you said, training people to understand what the impact of trade secrets and NDA leakage and so on is. And we also are quite open and communicating internally in Airbus. One of our highest IP risks is actually confidential information handling. In any aircraft program, we have about 800 to 1,500 technology development partners. Half of the aircraft is developed by third-party technology suppliers. So we have, if you like, massive risk interfaces where there's proprietary information flowing back and forth, where you have dynamic potential risk for exchange and misuse of proprietary information and trade secrets. So to us, it's we build our awareness into our ENC, our ethics and compliance framework, which is mandatory training ongoing every year. It's also adapted slightly to the cultures here. My teams work across UK, France, Germany, Spain, and India, and the US. Different cultures react in different ways to how they handle trade secrets. So I like this idea of, I can't remember what you were referring to, Bridget, with this contract, but NDAs don't work. But what we find sometimes does work is a written acknowledgement that someone has understood something, especially in France. This carries a lot of weight. So using these quite subtle cultural levers to really influence how the individual employees and engineers handle trade secrets is key for us. That's really what we rely on. Excuse me. So yeah, we exit interviews as well. That's a key one. And just ongoing live training when we have particular collaboration contexts, working with externals, we have specific training processes, and we'll put in place a governance that we then reinforce about how to handle proprietary or confidential information and trade secrets. We just work at it. It's awareness and education from our side, which is quite difficult to deploy across 4 countries in unison in 4 languages and in 4 different cultures. But that's really what we rely on.
I was going to chime in that, something that I think about a lot is just the complexity, and I'm always thinking about my job now and then what it'll look like 5 years from now, 10 years from now as it scales up. And at this, we have 1,000 employees, around 1,000 employees. And so the difficulties that I face are very different from what a company with 50 employees faces, are very different from what a company with 10,000 employees face. And I'm always thinking about it is a complex process. The risk around employment and mobile employees is a very, very dynamic one. It constantly changes, and it's very different based on a number of factors. I have found that it's very important to have the stakeholders. I have my people team, my information security team, my physical security team, intellectual property, and employment law all working together in order to come up with procedures that the company can follow in having these like best practices for trade secret protection, because it's not intellectual property, right? It crosses many areas as we previously mentioned, and having those grouped or be able to identify certain groups of employees that fit together with a certain pattern, and this type of procedures will work for this group of exiting employees in the maximum number of cases, can be very efficient. It doesn't catch everybody, right? It's imperfect. Trade secret protection is imperfect. You just have to do a reasonable job to try and prevent and mitigate loss, and to make sure that what you're doing is reasonable if somebody asks questions about it later. So it is something I definitely struggle with. I'm always very shocked by the companies that have these programs that they've rolled out to enormous number of employees to be able to handle those types of unique exits, because every single exiting employee is a risk factor, every single one of them. And you cannot, like I said, you can't work 24 hours a day to investigate the risks that are associated with each person, and you can't follow them throughout their lifestyle and sit next to them as they start their new job to make sure that they're behaving. So what are the actions that you can do in order to, mitigate the risks in the most efficient ways, given the constraints of your company? It's certainly not an easy answer, and one that I think I spend most of my days thinking always about how I can do it better. But there's no perfect answer. And it's a very challenging question for sure.
Yeah, I mean, I'll reinforce, what Bridget's talking about, right? I mean, even in a large company like Raytheon Technologies, we have a very small number of IP professionals relative to the size of the company. And, the number of people who are joining the company or leaving the company on any given day is massive, right? You couldn't actually have an IP professional speak to every engineer, let alone, the larger population of the company on any given day. So one of the important things that we try to do is to empower the managers, right? Because the managers know the person the best. They know what the person does day to day, right? They understand how they work. They understand, they have more insight than almost anybody else. The managers and the HR partners who help support them, are really kind of like the ears, the legs, the arms, pretty much everything for helping to identify those risky situations, right? As Bridget said, she's exactly right. There's a risk with every departure. And the question is, how do we triage that so we understand what are the ones that we need to spend more time and look at and understand? And even when we have employees coming in, where are those risk factors? Where is hey, by the way, look at this new piece of information that Maggie just brought in the door. It's okay, well, where'd this come from, right? Asking those questions, right? To help understand, is there something here that we should take a closer look at and understand? And also to allow those managers and the HR professionals to understand who they can call for help, so that you can run these things to the ground and understand it. And something else I'll highlight as well from Bridget's initial introduction, right, was the importance of making sure that you don't have a new employee bringing prior employees' trade secrets in, right? That is the nightmare scenario for all of us. And it's interesting, right? When you go in and you talk to a lot of your cybersecurity professionals, right, they talk about exfiltration. And one of the things I reinforce with them is we also need to think about infiltration as well, right? What is the information which is coming in? We need to tag this and be watching for that as well. And it's an important aspect to make sure that we have that bi-directional look at information entering our network and as well as leaving the network. So it's just an important thing to kind of remember that those cybersecurity tools can work in both directions. We just have to actually have them deployed to do that. And that's where the partnership with your cybersecurity folks come in.
I think that, Troy, is one of the highest risk areas we identify. And it's more in the context of technical partnering. You have a partner almost Trojan horsing into the company confidential or trade secret information. And we have to try and deal with that in a secure way. And it's a very, very high risk. And yeah, that's our main context for the highest risk, I think, in Airbus. I mean, for sure, exiting and entry of staff, but given that's a much lower figure than for us, it's really the interface with technical collaboration.
Yeah, I mean, the technical collaboration aspect, Alistair, I think we could probably do another session for a day or two on it. But yeah, I mean, because there's a real tension that develops, right? Because inside that's not technical collaboration, right? We provide engines to Airbus, right? We want to have the best possible airframe engine combination possible, which basically leads our engineers to basically push further and further, and sometimes over the edges, which we thought originally would made sense, right? And it's it's tough to kind of balance that and understand that and kind of keep track of that over time. Yeah, I mean, it's definitely a huge issue, which is independent of employee mobility even. So.
Another way that we triage, just to make a point, is we do differentiate between higher risk areas and lower risk areas. And even on exit, the European aerospace scene is, I'm not saying it's small, but people go inside a technical ecosystem. So quite often, well, it's possible sometimes to track or at least see where bad things happen on occasion. And we can put efforts on certain domains and less so on others because we don't have the resource to sort of do everything everywhere in the company. So that can help a bit.
Thank you all. I think that was a great discussion on that topic, and we've got some tips to implement as well as things to think about. But that brings us to our third and final topic. And for that, I'll go back to Troy here in the room. So we've touched on this already a little bit with the differences in how different jurisdictions in different countries and different nationalities handle things like culture, mobility, and other things. But here, what are the jurisdictional impacts and considerations on IP protection in the aerospace industry and specifically the space industry? And so Troy, turn it over to you.
Sure, thank you. So I'm going to go back to something that we've talked about multiple times here, and it's a question of the strategy. Because the tricky part is with respect to particularly patent protection, as we discussed in the first topic, it can get extremely expensive very fast, right? And instead of actually investing your money to develop your technology, bring it to market and commercialize it, you're now instead spending it, to pay patent attorneys like Graham here to, go and get you a patent, right? Or worse yet, to have a patent that disappears under a secrecy order. So the trick is try to understand that strategy. And it's basically trying to understand where you can get the right patent in the right place, right? That right place question is the jurisdictional question. Some of the things that answer that are kind of understanding who the likely people are who are your competitors, right? Who is going to be the ones who are potentially going to, take your innovation and use it without you. You are going to basically undermine your business. Understand where they're operating, what their essential supply chain is, what their path to market is. Understand where you're likely to go, and then on top of that, also understand what the jurisdiction looks like for you, right? If you're talking about a state-owned enterprise, that patent in that country being asserted against a state-owned enterprise, you're probably not going to get very far, right? It's a very difficult conversation to even start with. So the question is, how valuable is that particular asset, right? Do I want to invest a lot of money in that? Or do I spend some more money on some trade secret protection that makes it harder for somebody to actually get that innovation in the first place? Other things which I think are particularly interesting with space, right, is that we're rapidly changing our interface with space, right? Typically you'd have stuff assembled on a launch pad, it goes up as unitary payload, and it basically sits there and does things in space, right? It all came from a unitary payload. And basically from a patent enforcement perspective, the jurisdiction that you're launching from or that you assembled that payload is your primary nexus from a patent enforcement perspective, just thinking about it. As we start to look into the future, we're looking at proliferation of launch vehicles, we're looking at self-assembly in orbit, we're talking about, more autonomous operations in orbit, and then also crewed space stations as well, right? We have multiple efforts going forward to try to basically bring private crewed space stations to orbit. And it opens up in that new frontier, what does patent protection actually look like? So here in the United States, we actually have a patent law, 35 USC 105, that actually extends patent protection into US flagged space vehicles, covers for things like the International Space Station, future Artemis Station, and things like that. Most countries don't have that. So the closest that we have are things like the ISS collaboration treaty, which basically says that each module is the respective country's module. Right, so there's a European module, there's a US module, there's a Russian module, things like that. And essentially, when you walk from one area of the station to another, you're moving into different territories. And theoretically, the intellectual property laws in those different territories apply. But not all countries have enabling acts or action. So, as you start thinking about what the strategy is, like, what good is my patent in a country if I'm talking about something that's related to, say, a self-assembling space structure, if it doesn't ever touch that country? Or even if it's flagged in that country, it doesn't have enforceability in outer space. So, those are kind of things to think about. But the key is going through and trying to understand what the overall strategy is, right? As I'm going through, how much money and time do I invest in these patents? Where are the places where they're key, either as part of my strategy for making myself unlikely for somebody to go after me, or alternatively enforcement perspective and trying to basically stop or protect that unique invention that I brought to market for the term of the patent. And understanding like that investment relative to the investment that I have in trade secrets and the investment that I have in just going faster, Because sometimes, my best bet is to actually speed out in front of my potential competitors and bring the next innovation faster and invest in that. So that's kind of a quick overview with respect to jurisdictional aspects, and it's choosing that right jurisdiction based around those supply chains. Also, because of the aerospace industry overall, it's really important to understand regulatory environment, because the regulations will potentially change. It may create certain limiters or bottlenecks, which become important and potentially valuable, right? So that regulatory aspect of the market can be reinforced and actually reinforce your intellectual property strategy. So like a patent, which on the face of it looks very narrow and very focused, can actually be very valuable because of the regulated nature of the industry. And it's like kind of understanding the way those regulations play out relative to your products, and what are those key aspects which make it very difficult for somebody to come in and knock off those products.
Thank you, Troy.
It's a great topic, Troy. I mean, we could talk for days about this type of thing in a large industrial enterprise patent strategy and so on. I think we're pretty much on the same line with you. Our challenges are working across multi-jurisdictional innovation sources and taking multi-inventor teams across up to 2 or 3 countries, and then deciding how to deploy the patent filing strategy from there. But it's exactly the same. We look at individual jurisdictions. What does enforcement look like in each jurisdiction? That's a big one for us. Generally in civil aerospace transport, it's fairly clear: the US, Europe, China as well. We're hedging again in China. We're filing a lot of patents there. Looking at the supply chain, but looking actually at the practical challenges of enforcement and what that can mean for us in terms of cost and effort. And we put our efforts differently depending on where we see the higher value technology in the aircraft as well. But I think, as I mentioned before, we look at competitor positions as well as supply chain very strongly. I mean, we get probably as much value out of our IP, our patents, in procurement negotiations as we do in terms of defensive or offensive pure patent use. So that's a major element for us when we're working with suppliers and partners.
Yeah, I'll just chime in real quick on the point that Alistair made regarding the multinational innovation teams. That's true for a lot of our industry, and it's interesting the compliance headaches to actually go through with like filing a patent, right? When you have multinational inventor teams, and understanding the essentially the national effect of those teams, right? Because you'll have basically jurisdictions which are like, you cannot file a patent without filing in my home jurisdiction first. What happens when you actually have an engineering team which is sitting in multiple jurisdictions like that? It's just a headache.
We have somewhere it's actually impossible to satisfy the filing requirement.
Yes.
Regulations, certain accommodations of nationalities. It's a challenge.
Yeah, absolutely. Sorry, Bridget.
No, actually, I was just chiming in to say that I don't have anything to add, because I thought everybody answered the question so well. As I was thinking about this question, it struck me that a lot of the patents where jurisdiction matters are going to be things where the invention is not practiced on the ground, or it's, some combination of something on the ground communicating with something that's in outer space. A lot of that is not an issue with launch services. It can be, it certainly can be, but usually these things can be claimed in a way that exists at some point on the ground, right? That it's not the method of using them, but rather their structure that enables that functionality to happen, right? That exists as a tangible thing in some country, in some one country by one actor. It's certainly an issue with methods. This is a huge one. Methods performed on the space station for like drug discovery, drug development. Because I know proteins behave a certain way in zero gravity, and so that becomes enormously important for the people doing drug development on the space station. not so much, even with space vehicles and satellites, as I mentioned, it can be a method of their operation. We've definitely seen those types of patents. I think one that was really famously litigated a while ago was NTP and RIM were fighting about their BlackBerry patents because there was the control station and then the Blackberries, right? And where are those patents infringed? I can remember those. I had written a note about that, I think, in law school. So, but for the most part, just because of the lessons learned in NTP and RIM and some of the older cases that were its predecessors, I don't give that issue a lot of thought, at least for now, because most of my claims can be written in a way that are localized in one country by one actor. And that's what I'm striving to do for now. And to really think critically about that, because as you mentioned, foreign prosecution can be enormously expensive for a startup. And I think very critically about foreign filing strategy and how, I can position those claims in a jurisdiction that makes sense, right? Because I don't want this necessarily, I don't want to have to file a patent in 25 countries. I just can't afford that. So where can I file them very strategically and claim them in a way where it's going to make the most sense, right? Because I'm aimed to block import. I want to have things manufactured in that country, in the very few number of countries where it is and can be manufactured. And maybe less consideration to the countries that are providing launch services, right? Where enforcement might be harder or impossible, right? Like Russia has a lot of launch services, but I don't, I wouldn't bank my entire IP strategy around, Russia. So, yeah, I think about those very carefully, not maybe just more of the countries of our world rather than in outer space right now. So in the future, I do think it'll be very interesting to figure out how to best protect 3D printing in space, right? I think all day, every day about 3D printing, which is, one of the innovative technologies that sets relativity space apart from others in this area. So I'll be needing to figure out how best to protect 3D printing in space or in low gravity or on Mars or whatever. But I think that'll take an an effort among the international community about, us all agreeing on what that's going to look like. And for right now, there's just not a lot, right? So we have the US law and we have the International Space Station Agreement. And then I think there's some others, like Artemis Accords or something like that. I can't remember the name of it. But yeah, there's not that much out there, and they keep restarting it at WIPO every few years, and then it just kind of goes nowhere because the technology is just so nascent. But I'm sure it'll start accelerating because we have at least 2 companies right now that have announced missions, private companies that have announced missions to Mars. Yeah. And once the first one, the successful one goes there, there'll be lots of people following. So it's going to come soon, probably within my lifetime, which will be really exciting.
Yeah, I agree. It's particularly amazing to see the proliferation of space today, right? So back in my days as an engineer, I actually worked at NASA for a while and put stuff up, at an experiment that went up on the space shuttle. And, it's amazing to me the launch capability we have today compared to what it existed when I was when I was a new engineer. It's absolutely amazing. And very incredible. But Bridget highlights something really important, right? And that's the unity of invention and trying to make sure that your patents are drafted in a way which capture relevant units of the invention, which are practiced by a single person in a single jurisdiction, preferably, right? Or at least come together in a single jurisdiction. This is one of these things which I think, like, Alistair, Bridget, and I, we kind of look at and like, oh, well, that's why we hire good patent attorneys. Sometimes even a good patent attorney gets run astray because they don't necessarily understand the company's industry or like how people put things together or what like a unit of payload is for a particular application. And that's why, like, it can be expensive, but investing in your patent attorneys who are going to be drafting the claims, teaching them about your industry, how it works, how you actually put a payload together, how you actually assemble it, how it gets to the launcher and actually gets up into space. Helping them understand that is critical to getting a good patent. right? One that doesn't basically require you to sue 3 different people in 3 different jurisdictions, which, by the way, you'll never win. So it's it is actually one of the important ones. It's kind of tough to think about because outside counsel is expensive, but it's important to make that investment in your outside counsel so they really understand your business.
Definitely agree with that,
Yep.
Troy. One thing in my own early career dealing with early internet patents, server architectures spanning different countries, where would infringement actually happen? And what I see now is how do we look at distributed air traffic management systems that span different continents, different countries, aircraft traveling, which parts of the aircraft could be considered under the Chicago Convention for infringement. I mean, it's really complicated, and it's you have to really focus on the claim structure, what you're actually targeting, and think about it very deeply. It's a challenge.
Okay. Okay.
So I'll just make one comment about Alistair's mention of the Chicago Convention and kind of Bridget's, talking about kind of future treaties and stuff like that, right? Artemis Accords are kind of like, don't seem to be going very far, though I think the EU recently signed up for it. We kind of need something like a Chicago Convention type framework for orbital vehicles, right? There's kind of the start of that with the UN Convention of Space, but it's just not quite there. So I think that international harmonization that Bridget's talking about, I like the framework of the Chicago Convention, in terms of addressing some of the key critical aspects of it that, I think are open questions and causing challenges today. So anyway, sorry. Your question.
We have a question in the room, so that concludes our 3 topics, and we'll now go to the questions.
Okay, thank you so much. I guess one of the things you talked about was how different the challenge is when facing a state-based actor. Now, my question is, so what strategies would you suggest or should emerging or established companies like yours put in place when the threats could come from state-based actors?
Since I opened the door for that question, I'll go ahead and start and let Alistair talk. So I mean, there are a couple different things, right? One is the contractual basis, right? So how do I actually structure my contract with the state-based entity, right? That's kind of a starting point. The second aspect is making sure you have good hygiene, right? So like basically making sure that when I'm going through and working, I don't go too far, right? That I basically, respect those boundaries and kind of keep those boundaries tight. And then when I think about pure IP strategy, right, the answer is not 0, but the question is like, how much weight am I putting there, right? And that's kind of the way the question goes, is like, all right, if I would normally file, say, 20 patents here, I may only file 5 or 10 there, right? Not because they're useless, but because I have a much harder enforcement path ahead of me potentially. So, and then also, right, the other thing to think about, right, is that especially in aerospace, even large market like the US or the European, of themselves are not enough to support a lot of our products. They're actually truly international products. And when the product actually crosses international boundaries, there's other avenues for potential enforcement. So you kind of have to think about it from a global perspective, not just a local perspective.
Yeah, Troy, I think you've captured it perfectly. I was going to say that at the outset, for us, it's really knowing how far we can go with a state-controlled entity in an IP context, and trying to understand that before we really do anything, and putting our IP posture, framing it around the particular context, whether it's a state actor like a local Chinese government, one of the regions, or another context like that. It's knowing how far we can go and what the stakes are for the business. Just to add to what you've already said.
And are you able to access the chat, read in that question?
Oh, you don't have moments.
So So I guess with that, are there any other questions in the room or online? Got one here in the room.
If I may, so what happens process-wise when there is a breach from your company perspective, when there is a trade secret breach or something, especially if you're in a situation where you're having one of these multinational collaborations or any other kind of collaboration? What process does that trigger? And then also, how does that affect teamwork and culture moving forward if you have to continue working with different entities?
So I'll go ahead and start. I mean, especially in the context of some of like the collaborations and things like that, you'll have missteps, right? It's just the nature of it. They will happen. And, by and large, it's a matter of basically identifying it, cleaning it up, and moving on, right? I mean, that's kind of what happens most of the time. I think, there are other aspects, right? If you have like an individual employee who basically leaves, takes with them, a hard drive or something like that, right? Then you have a very targeted enforcement action. And you're not going to be, working with that employee in the future, right? So, those sorts of things can happen. But I think, in general, like especially when it comes from business to business, in the aerospace industry, we are, I don't know of anybody I'd necessarily call a bad actor, because like generally, like all of us don't want somebody else's stuff, right? And because of that, right, you usually reach out and basically go, hey, by the way, we have a spill that occurred here. This information, shouldn't be on your servers, and they work to clean it up, and we basically then move on. So, I don't want to make it sound all like milk and honey, but in general, we have a fairly common polarization in that we don't want to pollute our products with somebody else's IP that's inappropriately gained, and because of that, we all kind of usually respond fairly positively to that. If it happens continuously, yeah, you're going to start to put in some controls around the relationship that may change the character of the back and forth. But that's the nature, right? If you have a problem area, you're going to have to put some more process around it.
Just to add to that, I mean, our approach when we discover a breach of a trade secret or a situation is to ask the question really, firstly, does it matter? And to calibrate our response in that respect. I suppose one particular case, which is very difficult to manage, is where, especially in a collaboration where you may well have one party filing patents based on trade secrets of the others, even inadvertently. And yeah, it's public knowledge. We've had that happen a couple of times, and retrieving that situation is procedurally complex, where we will have, or someone will have third-party information, proprietary information in their patent, even if it's not claimed, it's published. And that can be very difficult to unwind. It can cause a great deal of distrust between technology teams. So there's a bit of a mea culpa perhaps on both sides. But there are so many interdependencies, as Troy says, within the industry. If we're working with an engine supplier, we know we're going to be working for the next 10, 15 years. So we have to sort this out, and we be upfront about it, fix the problem and move on.
And just to build on what my colleague said, what's interesting about this area is that there's no programmatic response because every situation is different, and so you can't say in all instances this is our path for responding to it. It's always a holistic risk assessment. Just like preventing that kind of loss is a holistic risk assessment. This is okay, how to calibrate our response to something that has occurred so that it's neither an underreaction or an overreaction, but rather just a Goldilocks reaction of just right, and that this is what's going to this is what we can do given our limited resources, because nobody has infinite resources to respond in all instances to trade secret loss in the same way. So yeah, it's you're looking into what is the value of the loss, what can be reasonably done to pull it back, right? In many instances, it can be pulled back and without compounding the loss. If there was something, a massive loss, right, where you find out that a former employee has now started a new business and is using all of your trade secrets in order to get a head start, and they do this big splashy launch, and you're like, wow, this is our technology. Exactly. That's going to have a very different response than maybe say a vendor who displays one of your parts while a competitor, they're working on one of your parts while a competitor is walking through the factory, right? And they can maybe get a glimpse of what a propulsion structure looks like. So those are just, I'm thinking of two hypothetical scenarios that haven't necessarily happened, but could happen in a space like this. And those would merit two completely different reactions to it. So there's no real protocol. It's just a holistic assessment of what the risk is and what you can do to react to it. That's why they pay us the big bucks.
Thank you. Great responses there. And so with that, I see we're at the end of our time. Thank you all for joining us today, and a big thank you to our three panelists. That was some really great information. Thank you all.